law at Boston University, and as well visiting professor at Harvard Law School. Professor Vlad Perju, please.
All right, thank you. Can you hear me?
Yes.
Okay, wonderful. So thank you very much for the for the invitation. Thank you to Camille. Thank you to Isabella. It's a pleasure to be here. So let me get straight to it. I see the ruling that annuls the presidential elections in Romania as the result of a constitutional court that found itself, partly because of how it boxed itself in through past cases, partly because of political circumstances beyond its control, in a situation where some intervention after the first round of the elections was simply unavoidable. Now, intervention is admittedly vague, so let me be more specific. Approached retrospectively, two things seem to me to have been entirely predictable, at least from early October 2024 onwards, if only one cared to look. First, that Călin Georgescu would not become president of Romania. And second, that if necessary, his not becoming president would be pursuant to an action of the Constitutional Court. Both statements are, in my view, indisputable as a matter of constitutional law, and unsurprising too, again, if one cared to look. But why look? Before election day, it made no sense to pay much attention to Georgescu, since his claim to the presidency was derisory. More on this in a moment. I mentioned the timeline, early October 2024. That is when, on October 5th, the Constitutional Court invalidated the candidacy in the presidential elections of another candidate, Diana Șoșoacă, on grounds that would be entirely applicable to Georgescu as well, even more so today than at the time. Namely, that through actions and statements, the candidate failed to meet what the court saw as a substantive constitutional criterion regarding the endorsement of values and principles of constitutional democracy. This is an admittedly very vague standard, open to much criticism, and I will return later in my remarks to it. For now, I mean to refer to this October 5th ruling simply as existing and applicable constitutional law. To say that this criterion is applicable to Mr. Georgescu's candidacy does not mean to say that it was applied. No opportunity to apply it presented itself before the election. That is, before the election, no one challenged Georgescu's candidacy on this or any other basis. The court thus did not have the opportunity to apply that criterion to Georgescu's candidacy and to invalidate it as unconstitutional. Now, to refer to something as unconstitutional candidacy is a very funny way of speaking, but that's the way in which the Romanian Constitutional Court speaks. So I will be using that language. Note the implications of this legal framework. A candidate whose unconstitutional candidacy has not been challenged and thus invalidated ends up running in the elections and could, in theory, be the winning candidate. I say in theory because no one thought that this was the case here. Georgescu's rise was like one of those highly improbable legal scenarios that make for good hypotheticals in law school examinations. They describe a situation that does not really happen in reality. Of course, unless of course, it does. Georgescu's win in the first round of the elections, and very likely win in the second round, presented the court with this problem, that of a winning candidate whose candidacy is unconstitutional. Now, it is possible to articulate a jurisprudential view whereby the sovereign people's choice, including in a presidential election, is always right, and therefore it should never be permissible to use the Constitution in order to invalidate the sovereign's choice. If that is your view, then there's a whole lot more in the Romanian or any other constitutional system that would need explaining. So I recommend setting aside that view for a moment just to follow the rest of the argument, which does assume that the Constitution, in some form or another, to some extent or another, places some structure around the people's choices. So take this to be a real problem. A winning candidate whose candidacy is unconstitutional. And that's a real problem at two levels. One is the level of legality, of enforcement of constitutional courts, of what to do about it, the kind of thing a constitutional court is supposed to care about. The other is a deeper social political level. I will return to the second dimension in a few minutes. On the question of on the issue of enforcement, how could a constitutional court, which declared itself the ultimate overseer of the constitutionality of the presidential elections, certify the result of an election won by a candidate whose candidacy is unconstitutional? It sounds like a bit of a rhetorical question, but it's not. And because it's not, the court stepped in. And it's unsurprising that it did. I personally wrote that it would, that the court's intervention was imminent right after Georgescu turned out to have won the first round of the elections. So did others. It was enough to read the court's justification in the Șoșoacă case to understand, first, that Georgescu was ineligible for the presidency, and second, that the court interpreted its jurisdiction in presidential elections so expansively that it would do something about it. I mean all this predictively. I mean it descriptively. I don't mean to say that this is a good thing. I don't mean to say that it's a bad thing. I will, but not yet. One last point while we're on the predictability issue. One might take the view that insofar as predictability is attached to the application of legal doctrines, ruminating about predictability would suggest that the court operates in a legalistic logic, when in reality, at least this court, the Romanian Constitutional Court, is driven by politics. So, for example, regarding Georgescu's candidacy, if that candidacy is unconstitutional according to existing law, does that mean that it will be invalidated if challenged, as it will be, in the upcoming elections? Yes, it does. But can one be sure that it will be invalidated when challenged? Can one be sure that the court will not disregard the applicability of its precedent pursuant to political calculation or even political order? Note that for that to be the case, this court would have to be not just political, but blatantly so. That is, in the most visible, contentious, and high-stake dispute in the country over the past decade, the court will have to ignore its case law and allow Georgescu to run in the elections. Will it do this? I don't know. I hope not. I think not, but I don't know. I would put it as highly unlikely. I will still put it, though, that highly unlikely that these two things will hold. Călin Georgescu will not become president of Romania, and second, that if necessary, his not becoming president would be pursuant to an action of the Constitutional Court. Now, the ruling of the Constitutional Court does much more beside pushing aside Georgescu's candidacy. It annuls the entire process. It orders the commencement of another cycle of presidential elections. It offers no time frame for that process. It extends the mandate of the president currently in office and so on. Thus, even if one believed, as I've just argued, that the court's intervention insofar as Mr. Georgescu's candidacy is concerned was justified under the existing legal framework, the same would not, and in fact is not true, about how and when the court intervened, the remedy it mandated, the justifications it offered. I believe that on all those grounds, the court got it wrong as a matter of constitutional law and constitutional politics. It chose the wrong remedy. It intervened at the wrong time and in the wrong way. Not all these mistakes are major. Some are minor, but others are not. I can't discuss everything, so let me be brief. First, it was, in my view, a significant error to order the remedy of a full redo of the presidential elections. I personally think that a better alternative would have been to order the second round of the elections with the candidates positioned in the second and third place in the first round of the elections. I'm not aware of anything in the statutory framework of Romania that required the court to order the remedy it did, but please let me know if I'm wrong about it. There might be something I haven't seen. Second, it was likewise a significant error, given the order to redo the elections, not to require an accelerated timetable for the new elections. This has had manifold effects, all of them bad. The search for new candidates, new political alliances, the extension of the president's mandate, the renewed attention on Georgescu and his acolytes, the country's diminished international position at this moment of political rearrangements in the world. Third, the opinion itself. The annulment of elections by a court is a hugely consequential decision that requires thorough justification. This is confirmed by the comparative law cases of courts invalidating elections, and one of the few instances where the opinion of the Venice Commission is actually useful on Romania. In the case of Romania, two issues stand out. First, the brevity of the opinion. It's strikingly short, 10 double-spaced pages. This might have been connected to it being a unanimous opinion, plus the fact that the reasoning was published the same day as the opinion, which is unusual for this court. Second, and related, the court invalidated the elections on the basis of declassified national security documents. These were deemed at the time insufficient. Many still deem them insufficient. It's interesting to look at the recent studies that try to delve deeper into what went on, including the one published a couple of days ago by the French government. There are reasonable concerns about the role of the security services in the lead up to the decision of the court. And finally, in my view, it was a mistake, though understandable, that the court certified the result of the first round of the elections after the full recount it had ordered before annulling the elections. The elections should not have been certified, given the unconstitutional candidacy of one of the candidates who qualified for the second round. The court issued a communique that it would address these matters when certifying the final result of the elections, though if the matters had gotten to that point, the pressure on the court with regard to the validity of the candidacy in the winning second round would have been immense. Let me now say a word about the second dimension of the problem, a winning candidate whose candidacy is unconstitutional, sort of the broader dimension. Georgescu is not like any other candidate, not because he's unconventional, but because he didn't seem much like a candidate at all. We're learning more and more about his campaign, who paid for it, how it was conducted. All of it is deeply concerning. All of it is showing the deep rot in the Romanian political world. But at the time when the Constitutional Court issued its opinion, he was seemingly coming from nowhere. He seemed to have been entirely absent from the traditional means of campaigning, no campaign appearances, close to zero name recognition. He'd been living abroad for over a decade. His substantive views made him the laughing stock of a conspiratorial nut about the nature of water, the pyramids, aliens, and all the rest. He rose because of a heavily illegally funded online campaign that in just a matter of a couple of months would bring him from 2 or 3% to a winning 23% of the vote, despite his lingering around 8-10% in opinion polls closest to the election. I mean all this to say that he posed a challenge that I think is not easy to formulate. But the closest I can come to it is a challenge to the intelligibility of the political space. Democracy in the form of representative government is based on an assumption of basic social intelligibility, that it is possible to understand by and large how power works, how the people elect their representatives, what these representatives do, and how they do it. Now, we know that nothing is simple about all this. But still, I think the gist of it holds true. I don't mean to open myself to the usual critique that anything that surprises political elites they deem unintelligible. Nor do I want to frame the situation as a puzzle to which the solution is electoral detachment or alienation. To some, I admit, this too will be a sign of the alienation brought about by powerful interests that have hijacked our politics. That might very well be right. But the search for the deeper social and economic causes does not solve the short-term constitutional problems. And the preservation of intelligibility is one of them. And I mean what I say is a constitutional problem. Finally, since my time is running short, let me say a word about the October 5th ruling, which plays a big role in what's going on here. This is the ruling where the court invalidated as unconstitutional the candidacy of Ms. Șoșoacă. The court deemed that the candidate's openly anti-Semitic and anti-constitutional statements and actions violate the Constitution, since, in the court's view, the Constitution does not allow such views from a president, neither does it allow from a candidate to the presidency. Thus, the court gave itself the authority to review and invalidate candidacies that do not meet these constitutional standards. The opinion has been roundly criticized. One of the candidates in the upcoming elections in May, Crin Antonescu, compared it recently, just a couple of days ago, to the opinion of the Iranian Guardian Council that decides which candidacies are allowed and which not. A comparison with the Russian Supreme Court or any other such institutions would also be in order. Compare all this to how things operate in the United States, where the Supreme Court of the United States said, interpreted the Constitution to give the people full freedom to want to vote, to vote for whoever they want to rule them, including someone like Mr. Trump. Now, it is true that Șoșoaca's case is the first time that the Romanian Constitutional Court strikes down as invalid a candidacy in presidential elections on substantive grounds. This is important, since in the past decades, there have been candidates who surely failed to meet the substantive threshold, at least as much as Ms. Șoșoaca, or indeed Mr. Georgescu himself, faced with challenges to their candidacy, and I'm thinking here of Corneliu Vadim Tudor, Gheorghe Funar, and others. The court dismissed those challenges. However, there's a catch. First, all of those challenges were challenges to various formalities of the presidential candidates, usually involving the number of signatures that the candidate needs to present in order to register a candidacy under Romanian law. None of those challenges involve substantive criteria, as in the Șoșoaca case. Second, the court ties the application of the substantive criteria to amendments to the Romanian constitution that instilled the country's membership in NATO and the EU. In other words, the substantive commitments are listed in the constitution itself as amended. Where does all this leave us? In a very hard place, to be sure. There is no doubt that these substantive criteria will be used to challenge presidential candidacy in the future. And there is no doubt that this will give the constitutional judges enormous power, including opportunity for abuse. If the past is any guide, then we have very good reasons to worry. At a minimum, it seems to me necessary to alter, through legislative changes, the procedure to be followed by the court when adjudicating these challenges, specifically in order to ensure that minimal procedural rights of candidates are protected. The Venice Commission makes a similar point in its report. That might seem like a small problem. A bigger one is that these are constitutional quicksands. But then again, how surprising can these developments be, given the political turmoil of our times? To be sure, one might have hoped that precisely during these times, the Constitution will provide some stability. But with Russian troops to the north, with a Hungary whose corrupt and xenophobic leader is celebrated as the great rethinker of democratic government, with a struggling with EU, with a United States that has gone rogue, in times like these, stability might be wished for, but it cannot be expected. And so, then we need to see these challenges to the electoral process, these political turmoil and constitutional developments today in Romania, tomorrow, I fear, elsewhere, as part of a larger story of political self-government whose ending no one yet knows. Thank you.
Thank you so much, Vlad, for this very rich and very substantial, very dense presentation. I suggest we take all the three first round of presentations, right? And then we move towards the second part of the meeting. That means that we are going to move now to Professor Bogdan Iancu, who is Professor of Political Science and Constitutional Law at the Bucharest University of Bucharest. Please, Bogdan.
Thank you, Camille. Yeah, of course, I won't reiterate some of the arguments that Vlad has already made and which I share. Perhaps I don't share this optimism in the effectiveness and efficiency of legal instruments to solve such problems. Now, but I'll try in a few words to put this in context. What happened in Romania was presented as an instrument of militant democracy. So that's the idea, that this was an instrumentality of militant democracy in Romania, and already the Romanian case is being placed in a broader context. Vlad has already alluded to this. Also, Thierry Breton mentioned that in the context of the German current problems. We live in a united Europe where precedents travel quickly. Now, militant democracy. Now, constitutions after the Second World War, of course, adopted instruments of militant democracy. I won't do a literature review, in the sense that they took the lesson from Weimar seriously. Now, that was the idea, that we take the lesson from Weimar and we adopt instruments of militant democracy. What basically happened was that, to paraphrase Jan Werner Müller, a Kelsenian solution to a Schmittian problem was found. The Schmittian problem, of course, and the Lowensteinian problem was combat enemies of democracy with harsh measures. Lowenstein advanced the term first in 1937 in the American Political Science Review. I won't reiterate the whole argument, only the essence of it. The essence of it was that fascism is not an ideology, but a technique. There's nothing substantive behind it. It's just a technique of power that relies on what? On the emotionalism of the masses. Masses are emotional, they respond to emotional stimuli, and since this is a technique, one has to counteract it through technical means. And in the second part of his article, Lowenstein enumerates a number of proposals to counteract fascist emotionalism. Party bans, of course, meeting restrictions, restrictions on speech, offenses to authority being incriminated, offenses to public symbols, the creation, interesting, of a political police. He stresses that it is important to create an independent political police and also to incriminate those who do not collaborate with the criminal police, who do not denounce attempts to overthrow the democratic order. And many other proposals are being made, but that's the crux of it. Lowenstein, of course, restated a Schmittian idea. Namely, Schmitt famously said that liberals are too neutral, overly neutral. They cannot distinguish between foe and friend. And put in front of a choice, in the horns of a dilemma, of a choice between Christ and Barabbas, Schmitt says, the liberal will either defer the answer or propose the appointment of a parliamentary committee of investigation. He doesn't know how to choose. So one should choose between the friends and the enemies of democracy and act resolutely. In Schmitt's instrumentarium of means to counteract foes of democracy, the Weimar democracy at the time, Article 48, the dictatorial power of the Reich president, was at the foreground. Now, so the idea was we adopted these instruments, we took the lesson seriously, and now democracies can defend themselves against their enemies. Party bans, in the case of Germany, also forfeiture of basic rights and a merely symbolic right of self-defense. Now, there's a problem with that picture that may be also useful to us now. What is the problem? If you look at the realities of Weimar, during the Weimar Republic, such instruments existed plentifully. Now, I won't go as far as Gertrude Lubbe-Wolf as to call the whole story about militant democracy in the Basic Law of 1949 a Selbst- and Lastungslegende, a self-vindication, a self-justification fable. But if you look at the Weimar Constitution, there were, in the two laws for defending the Republic of 1922, of 1930, there were ample instruments. And there were, in fact, many party bans, hundreds of them. Suspension of newspapers was possible very easily. Suspension of periodicals. the criminal law contained a number of instruments. It is true, if you look at them closely, you see that they were used more harshly against the communists rather than against the fascists, but that's a different story. So if anything, it was easier to combat enemies of democracy during Weimar than it is under the Grundgesetz. No? And of course, I forgot to mention it, Article 48 always stood at the ready. During the 14 years of Weimar, 9 years and a half were under Article 48 dictatorial presidential dictatorship decrees. So 9.5 years of emergency. And Article 48, of course, was very easy to use and ample in the possibilities that it provided to do anything from a party ban to the setting of a court, of an extraordinary court, all the way through to conscripting a government that would not collaborate with the imperial, with the central government in Berlin, as it happened in the Preußenschlag, as it could have happened at any point, even during the Ebert presidency, when the Bavarians took exception at the beginning to the first law for the defense of the Republic. There's yet another problem, namely that the instruments that were taken over in new constitutions, in the case of Germany, they certainly were underused. It is true that the Federal Constitutional Tribunal declared two parties unconstitutional in 1952, a neo-Nazi party, in 1956, a communist party. It took a much longer time to decide on the communist issue for obvious historical reasons, and a much longer decision, about 600 pages long. But afterwards, it never declared a party unconstitutional ever again, as one can see with the shenanigans regarding the NPD party ban, the stay of the decision in 2013, and the negative resolution in 2017. As for the forfeiture of basic rights, it was never used, no? Ever. So in countries where such instruments were used, the results are ambivalent. I don't have the time to go into that. No? In the case of Romania, what's peculiar about the two rulings, not decisions, of the Romanian Constitutional Court, and there's legal importance, relevance in the fact that they are rulings and not decisions. Hotărâri. So in these two cases, the Constitutional Court of Romania does something that's very innovative. Namely, it doesn't apply militant democracy in the Western style variety, even though there is an instrument in the Romanian Constitution, Article 146, letter K, the possibility to declare a party unconstitutional, which was never used in practice by the Romanian Constitutional Court. Now, the Romanian court imports militant democracy into rulings. First, the validation of presidential elections. First, the ruling that Vlad also mentioned, the Șoșoacă case, ruling number 2 per 2024. Then the invalidation of the presidential election, both rounds, the invalidation of the entire election, ruling 32 per 2024. So what the Romanian Constitutional Court does is what a few doctrinal authors have proposed that it should be done instead of party bans, namely individual militant democracy, as Jan Werner Müller calls it. It's his term, he coined it. Individual militant democracy. So instead of banning parties, or instead of banning parties for the purposes of election, that's Isaharov's proposal, one should concentrate on leaders, on individuals, you know, that subvert, that threaten the democratic order, which is an easier to justify solution and perhaps a more effective solution than party bans. Gertrude Lubov-Wolf, the professor and former judge of the Constitutional Court of Germany, also proposed that. But note that in the case of Germany, there is actually an instrument for feature of basic rights, Article 18 of the German Basic Law. So there is an actual provision that can be used. What the Romanian court has done, it has imported this sort of justification into the invalidation of a candidacy and then the invalidation of the presidential elections recently. What is the problem with that? There are many problems, and all of them are legal. Namely, there are precedents, and here I differ from Vlad, namely the aptitude, democratic aptness of candidates was challenged before, but the Romanian Constitutional Court stated specifically that that is not for the court to measure, that is for the electorate to decide in free elections. So there were not merely formal complaints, and the court specifically said that we won't go into the person of the candidate because that is up for democratic resolution at the ballot box. Now, in the invalidation of the Șoșoacă decision, it is true that the court stressed emphasis on the issue of Romania's NATO and EU membership. The problem with that, of course, is that a presidential candidate, God forbid, that would run on the initiative of getting Romania out of NATO or the EU would not necessarily be unconstitutional. These are, it is true, treaties that are ratified through a specific procedure. So the Constitution recognizes the fact that Romania's membership in NATO and the European Union is of constitutional relevance. But it is a constitutional relevance that is relegated procedurally and therefore also substantially underneath revisions of the Constitution and underneath the core of the Constitution, the eternity clause in Article 152. Such a candidate would certainly be a fool, but it would not be an unconstitutional fool, or at least the Constitutional Court would not be called to pronounce itself on such an issue. With regard to ruling 32 that invalidated the election, the problem is that the only justification that the court gives for issuing this ruling is its general supervisory power under Article 142 of the Constitution that says the Constitution is the guarantor of the Constitutional Court is the guarantor of the Constitution, is the highest authority that safeguards the Constitution. Hüter der Verfassung, right? That's the Romanian Constitutional Court. The problem with that is that this is a preambulary and general definition of what an institution does. Neither the president nor the parliament is the supreme representative organ of the Romanian people, can derive concrete procedures and concrete powers from a general definition of what the role of the institution is in the constitutional architecture. You need a procedure. A procedure did not exist either under the Constitution or under law 370 per 2004 on presidential elections, or under the organic statute of the court, law 47 per 1992. So there was no specific provision, and courts are famously, that's Alexander Bickel, reactive. They cannot intervene to do something. And here we go back to the initial problem. This is a Schmittian issue. How do you distinguish friends and foes of the democratic order that is entrusted to a Kelsenian institution, a constitutional court, which, albeit political, it is still a court. So if the result that the Constitutional Court reaches is desirable, and it is certainly desirable for me personally to not have Mr. Georgescu as the president of Romania. Now on that we can certainly agree. That is not the crux of the problem. The crux of the problem is how you get to that. So if the entire procedure if the legality of these rulings cannot be substantiated in any way, no matter how many somersaults we do, logical, philosophical, under the veil of ignorance, Rawlsian, Razian, right? So no matter what we do, it is very hard to justify in law, according to precedents, to specific provisions of the organic statute of the Constitutional Court, specific provisions of the Constitution. It's very hard to make sense of either of these two rulings. No. So that's probably because the legitimacy of the court does not reside in the goodness that it does. It resides in the way in which it does that. So you cannot be a Schmittian defender of the Constitution in Legalian, in legalistic garb, going against all possible, imaginable constitutional and organic legislative rules. That leaves us in a dilemma, because both these reactions, these knee-jerk legal reactions to control the process through institutions to stabilize it, this is not the first time it happens. It happened during the anti-corruption period. It happens now with the Constitutional Court. Respond to caricatures of democracy, such as Mr. Georgescu certainly is. No? Both of these reactions appear from somewhere. No? They are created by a context. A context that reveals various problems with education, regional inequalities, lack of infrastructure. So my personal preference would certainly be to look more at the causes that make people vote for Mr. Georgescu, even though I surmise that many of them realize the absurdity of many of his positions. The problem with that, of course, and I'm truly pessimistic about this, because to solve these deeper problems, you need time that we certainly do not have, and you need structures of incentives and disincentives that the polarization in defender of democracy, Mr. Georgescu, or AfD in Germany, for instance, on the one hand, and knee-jerk reactions masquerading as rule of law to control outcomes, right? Cannot stabilize. So these reactions cannot ensure the responses that would be needed to control the deeper causes that have led us here. That's pretty much all I have to say about this. Thank you.
Thank you so much, Bogdan. Thank you also for sticking with the time frame that we have so that everyone can also participate to this really important debate. Now I'm moving to Professor Sergiu Mișcoiu from the Babeș-Bolyai University in Cluj, Professor of Political Science. Please, Sergiu.
Thank you very much, Camille, and thank you for having me with you. So I'm not a specialist in law, but I'm rather a political scientist. And I would like to start by saying that although the decision of the Constitutional Court was perceived by many as constitutionally and also politically problematic, it was also seen, and we have to be honest, as the only immediate and effective solution to prevent the fail of Romania under the influence of illiberal forces and even maybe more severely under the geopolitical influence of the enemies of the European Union and NATO. And for many, this was a relief. So for those among us who do not know who Călin Georgescu is or what kind of forces that he represents, maybe just a very brief comment on Georgescu. He came allegedly from nowhere, but he was fomented in the logic of the former secret services in Romania, with a huge amount of connections at different levels of the state and of especially the force agencies. He was the only one addressing part of the Romanians who are, according to the polls, at around 30%, and who are daily consumers of a very strange mixture of astrology, alternative medicine, theories of plot and other such things. Georgescu speculated the spiritual crisis of the Romanians, creating an ideological synthesis between different currents, from classical sovereign nationalism through fascism, orthodoxism, national communism, Deism, meaning the cult of the Deises, the ancestors of Romanians, allegedly on this part of Europe, and on the top, New Ageism, esotericism, a mixture of ultra-veganism, neo-ruralism, mystical connection with nature, everything in with a common denominator, which was the quest for some sort of collective redemption by this fusion with the providential man. And this was, of course, the natural component of his success, combined with the less natural component of the success, which was the help provided, as it was said here, by different entrepreneurs coming with direct connections with the Russian secret services, to make a long story short. Now, so this decision of the Constitutional Court was seen as a remedy and even as a salvation on a short term, but of course put us in a difficulty, because it was presented as being a manifestation of what we may call the gouvernement des juges, which is a common topic in criticizing the elites all over the world. And the first question I would like to address is if we are indeed under the gouvernement des juges with this decision. And then further on, I would like to present you some responses, some answers provided by the Romanians themselves that I had the occasion to interview, precisely about this decision of the Constitutional Court to go on the other end. So the of the perception of the Romanians about this decision. So are we under gouvernement des juges? We have many criteria to describe what Michel Troper called the critarchy, which means the power of those who judge. And if we take the main two, we are in a gouvernement des juges if there is discretionary power of the judges, who could infringe the laws through their sentences and determine themselves the reference standards for their control. And I really think that Romania seems to be at most only very partially in this case, but mostly it doesn't seem to fall under this first criterion. But then the second one is that we are under a gouvernement des juges if we have, and this is restrained to the constitutional judges, the exercise power to significantly change the legislature based on the adequacy of to the letter or to the spirit of the Constitution as interpreted by the court. And Romania seems to be at least partially under this second configuration, restraining the definition to the constitutional judges, and finding that these judges have a margin of maneuver which is too wide in interpreting the letter and the spirit of the Constitution, to cancel laws, to cancel also in practice different processes happening in the country, such as the presidential elections. Now, however, I think we have to ponderate these critiques against the gouvernement des juges by using the logic of Hans Kelsen, who believes that the judicial control of legislation is necessary as a correction to prevent an unrestrained majority rule, that the fact that we apply the law is as political as lawmaking itself, and the application of the law is a part of a political logic, which is only very partially and in minority a legal act, but it is rather a political action. And then there is this authentic interpretation, according to which a legal organ can also produce a norm that lies completely outside of the framework of the established standards. And this creates, of course, a certain dominant view over how the law should be interpreted and also should be applied. So does this pose a threat to democracy by limiting popular sovereignty, or it is rather a necessary safeguard against democratic backsliding by ensuring the protection of fundamental principles? This is a almost classical question now, and I tried to discuss with the regular Romanians who had different opinions about these this decision of the Constitutional Court. According to the poll that we dispose of, and there are two polls and they are rather concording over the results, 60% of the Romanians believe that the Constitutional Court's decision was bad, 25% believe that it was good, and 15% do not have an opinion about this. And so I tried to have a series of interviews. I succeeded to have 30. I wanted to have more between the 20th of December to the 25th of January 2025. 18 proportionally dispatched according to these percentages. So 18 people who were against the decision of the Constitutional Court, 8 who were in agreement with it, and then 4 who had no opinion. The profiles were very varied. They, of course, this is not a statistically representative inquiry. This is not the purpose. The purpose is rather to understand the logic and the motivations of the individuals. And so I drafted an interview guide meant to first collect spontaneous opinions of these on the issue and gather these opinions into topics. And then, of course, if these opinions did not came very clearly in the discussion, there was a relaunch phase meant to test the way people position themselves in relation with these two predetermined views about the role of this gouvernement des juges. So on the first variant of possibility, it's the decision of the Constitutional Court, a syndrome of a democratic crisis. Of course, a first argument was that it undermines popular sovereignty, democracy being based on the principle of popular sovereignty expressed through universal suffrage. Judges are nevertheless appointed and not elected, and so their decisions escape democratic control. And when they overturn decisions made by the people, being laws or results of different elections and many other cases, they are an elite seizing political power. And the discussions I had on this with the voters resulted, of course, in critical opinions about the decision of the Constitutional Court, as it could be expected. I quote Jon, an engineer, who told me, "The people have spoken and the court stole the people's decision. It is as simple as that." Or Denisa, an accountant, who said, I quote, "The people's decision needs to be respected and not overturned by the courts. That is the spirit of democracy." Then a second argument here is that we are in front of a risk of a technocratic drift. So the judicial decisions rely on different complex legal texts and complex reasoning that are often very disconnected from social and political realities. And that this legalistic approach can create a gap between judicial institutions and citizens, fueling in this way the distrust towards a system perceived as being opaque and unresponsive to popular concerns. Indeed, this appeared in the discussion, and I quote Laura, a saleswoman, a very simple lady, who said, "We are expected to bow in front of the legal competence of these judges who treat us like we were idiots." Or Miora, a teacher, who said, I quote, "If the system is so complex that it cannot, I cannot understand it, why on earth are they asking me to vote, to pay taxes, to serve them?" So a question about this risk of technocratic drift. Then, of course, it was very much present in the discussions, the partisan politicization of justice. When these courts intervene, especially in sensitive issues, they are accused of acting as political actors rather than neutral guardians of the law. And this dynamic can escalate tensions, of course, between branches of the government, but also the government and the people itself. And indeed, for instance, Sandu, an electrician, said there is no doubt these judges are the puppets of the politicians who appointed them. Or Paula, a student, who asked rhetorically, "What justice is that? It's blind with regard to the common interests and very accurate when it comes to the interests of the politicians." So these ideas and quotes go towards the idea that we are facing, in the opinion of many Romanians, a problem related to this decision of the Constitutional Court and generally this relation between the Constitutional Court and the political system and the people itself. Then, on the other hand, it could be seen as a remedy in times of crisis. And this was also present in the discussion. And I have to confess, I was astonished by the fact that many people also regarded from this particular lens this argument. So many can argue that in modern democracy, this is a vital role. Especially by upholding fundamental principles and ensuring the rule of law. It is a check against government overreach and against abusive majority. In many cases, governments have sought to weaken checks and balances by attacking judicial independence, and we evoked here Hungary and Poland many times. In such cases, constitutional and supranational courts serve as rather barriers against authoritarian drifts and block the erosion of fundamental rights. For instance, one of the respondents, Dan, a musician, said we need a shield against the abuses of the governments. Or Elvira, a retired woman, who said, what would happen if the government had the whole power? Potentially, the court remains nevertheless our last resort. So there is also in the public consciousness, in spite of what was said, especially in the media, this idea that in the end there is a rampart function of the Constitutional Court. Also, it could be said that it is a guarantee of fundamental rights. Constitutional courts protect individual freedoms, ensuring non-discrimination, ensuring safeguarding, for instance, social justice, and this is in the spirit of the constitutional values. So in this sense, judicial governance can be seen as some sort of a mechanism that ensures political decisions in conformity with the democratic commitments. This was also backed by some of the participants to this inquiry. For instance, Walter, a medicine doctor, who said, I quote, "One could very well say that by annulling the elections, the court defended our fundamental right to have free and fair elections." Or Rodica, a school counselor, who said, I quote, "Ideally, the judges should protect the weak against the abuses of the strong, the minorities against the discrimination of the majorities." So, interesting enough, this is also in the minds of many people. And finally, in this positive argumentation, stability that came in the discussions, also in the presentations of Vlad and Bogdan. Its Constitutional Court is a stabilizing force in times of crisis, especially in times of political fragmentation, where governments are unstable or weak. The Constitutional Court can help maintain institutional coherence, ensuring the continuity of democratic principles. This was also embraced by some of the participants to the inquiry. Zoltan, a worker, who said the decision of the Constitutional Court prevented the chaos that could have been created by the election of, I quote, "an insane president." Or Diana, an IT expert, who said, "Our systems of governance are sometimes in turmoil, and the court could act as the sole reasonable entity which enforces the law." End of the quote. So to conclude very briefly, the gouvernement des juges is a complex challenge for contemporary democracies. While it can be perceived as an encroachment on popular sovereignty, it also acts as a safeguard against authoritarian tendencies and also populist excesses. Now, from framing the debate as a binary opposition between judicial and political power, now we have an evolution towards a frontal opposition between, on one hand, the elites, the courts plus political power, and on the other, the people and the populist leaders. And this kind of fallacious representation is spreading all over Europe, and Romania was one of the cases very recently. Nevertheless, as this series of interviews I tried to conduct proves, I think the individual's opinions are sometimes surprisingly nuanced and quite split, far from this apparent blind rage of the masses that was presented as being as leading us all ineluctably towards a victory of the illiberal forces. Thank you.
Thank you very much, Sergio. And I am very happy that we now can move to the second part of our presentation, our meeting. What we agreed is that we're going to give the floor now to three discussants. So I include here as well Balázs. So starting with Dietmar, and then Renata, and then Balázs. For each of you, I would perhaps ask you to maybe think about 7 minutes of presentation, so that in total we have a 20 minutes discussion participation, so that afterwards we open up the debate for the public that has also joined us. We have more than 60, 60 something participants in this meeting, and for the broader audience, our suggestion is that if you have questions, you should write them in the chat of this Zoom meeting, because the kind of technical limitation that we have during this meeting would be that only the speakers that we have announced have these self-control of the camera, own control of the camera and the microphone. Everyone else will have to interact with us through the chat room. So please feel free to ask questions. We are going to read them in order for them to be addressed by the speakers. Now I will invite Dietmar Müller to speak as a discussant. Dietmar is a professor at the Institute of Political Science at the Leipzig University. So please, Dietmar.
Yeah, thanks a lot, Camille, and thanks a lot to and thank you for the three great presentations. Well, I prepared initially more questions than comments. Let's see, as a lot of things have been addressed already. Let's see what is being left of it. Both Vlad and Bogdan, you have alluded to the precedent of Diana Șoșoacă being thrown out of the election previously. Initially, I wanted to ask how likely do you find it that Georgescu, in the case he's running again, and Șoșoacă will be excluded again? Since well, to my reading of the reasoning of the Constitutional Court for excluding Șoșoacă, it's not identical with the reasons for canceling the first round of the elections. There are differences, but some of the reasons for excluding Șoșoacă would apply for Georgescu as well. And the more practical question: have they, so both Șoșoacă and Georgescu, announced already that they would run for the next round? So that would be the first question. The second, there was little talk about the Venice Commission's report, to my mind. What do you make of that? So to my understanding, I'm a historian, so not a lawyer, not a constitutionalist, but to my understanding, the Venice Commission's report shows quite some understanding for the Constitutional Court's decision. So it endorses the point of non-disclosure of election campaigning funds, as well as the sovereignty point, considering external influence by social media, sponsored and financed from abroad. And the third question, we know, of course, that Romania is not the only country being exposed to interference in the election process in Europe and globally. So let me ask the following: what can the Romanian Constitutional Court's handling of the case contribute to generally tackling interference via social media in the guise of militant democracy? Thanks. That's already my questions.
Thank you. Thank you very much, Dietmar. I now pass the floor to Renata Waits, who is a professor at the Democracy Institute of the CEU, as well as the Royal Holloway University of London. So Renata, you have 10 minutes or more if you need for commenting on the previous presentations, please.
Thank you very much, Camille, and thank you for these great presentations. It was excellent to hear my dear colleagues who I haven't met in a long time in person. So crisis always brings us together. Now let me give a bit of a context and the world tour before I put questions to all three of you. And of course, the context is that when Bogdan and I went to school, the fact that constitutional courts are also top electoral, they are in the job, their job description includes validating electoral results, was thought as one of the lesser technical competencies. And these powers were included in the third wave constitutions in the early 1990s, more or less as a copy-paste from the French Constitution. These were thought to be the least exciting powers, more or less as a technicality. And most of the time, constitutional courts were loaded with this power because nobody else could really be trusted with this, right? So essentially, when we see the Romanian court's power over elections today, we see something that was more or less a historic accident. And it receives and a benign historic accident. Nobody meant these courts to enter into megapolitics on account of validating electoral results. Of course, when the power is not validating electoral results, when the power is actually looking at the legality or constitutionality of the conduct of the elections, then all of a sudden the most elitist constitutional actor out there is pitched directly against the sovereign that expressed its will in the single most important event of a constitutional democracy. And what we see in the past few years, and both Vlad and Bogdan pointed to this, is that with illiberal rulers routinely questioning the legitimacy of elections and the manner of conduct of elections, this power becomes highly problematic for people who think about the point and purpose of constitutional democracy versus majoritarian democracy. I mean, let's just take a step back and see the difficulty of the question the Romanian Constitutional Court faces. Ultimately, they needed to look at irregularities about that improperly influenced the election's outcome. Now, if you look at decades of election monitoring results from the OSCE, you will find that the OSCE election monitors tolerate irregularities of really severe kinds, partly because they are unwilling to say that certain elections need to be rerun. They will regularly say that, you know, the elections may not have been totally free and totally fair, but were conducted all in all okay, and let's move on. And the closer you try to play with the rules on improper and influence, the closer you get to the language of the Russian foreign propaganda, of the Russian foreign agent laws, which try to rule out improper foreign influence from domestic politics. Most recently, such a law was elected in Hungary. Now, just think about how easy it was on the one hand for illiberal rulers to change the constitutional imaginary, that it's now routine to say that if you don't win, the elections were stolen. And how difficult it is for constitutional design to respond to this. So in 2000, and this is where the world tool starts. So in 2010, when the Kenyan constitution was redesigned fundamentally after massive electoral disruption, a commission which was put to task to look at electoral jurisdiction in particular recommended establishing a separate specialized electoral court. And then the constitution makers gave this power back to the Supreme Court almost by default. The Supreme Court keeps validating electoral outcomes in highly contested elections in dubious circumstances that undermines the legitimacy of both the court and the electoral outcome. What we have seen in Brazil in the last 2 years is actually pushing the boundaries of what electoral justice is about. And it's a very interesting development that, I mean, probably most of you in this room know that the Supreme Court's electoral formation banned President Bolsonaro for 8 years from all public office. because of abuse of power, and especially because of the lies, unfounded claims he made about electoral misconduct to foreign ambassadors. The Brazilian Supreme Court followed with a string of judgments concerning the campaign and disinformation way after the elections were actually over, which suggests that the time span in which electoral justice can be done is not only before and during elections, but also in response to elections. Now, this came at a very high price in Brazil. Earlier, a few months ago, it was revealed by the Brazilian police that Bolsonaro actively conspired in order to not only to steal the elections, but also to try to murder the justice who was the president of the electoral formation of the Supreme Court. So taking this to Europe and mostly to think about the Venice Commission's opinion, which Vlad mentioned, the opinion is not about second guessing the Romanian Constitutional Court. The opinion literally asks, what are the European and international standards for invalidating elections at large? This is an extremely important question because of the temporality of electoral justice. So in cases where the European Human Rights Court gets to hear about national elections, they usually decide 8 years after the fact. So 2 electoral cycles after a particular violation may have happened, no matter how grave this was. So in terms of the biorhythm of electoral justice, in 2022, several civil society organizations were fined in Hungary for improperly interfering with the referendum with the referendum proposed by the government, because they were encouraging voters to cast invalid ballots. According to the standard jurisprudence of the European Court of Human Rights, this is a very proper exercise of freedom of expression. The Hungarian Supreme Court was split. This is the 2020 spring elections and referendum. The ECHR is yet to communicate this case. From the time of communication, it will take 8 to 10 years to reach an actual judgment. By that time, we will probably have had 2 more elections with the victory of the greatest master of all, Viktor Orban. So let me put a question to each panelist in reverse order, actually starting with Sergiu. So I take it that we are in the age of gouvernement de juge or juristocracy. Is that a bad thing? Who is best situated to act on the intelligence shared by the Romanian intelligence services in this particular scenario? So I take that this is a high act of juristocracy, but who else could have acted on the intelligence findings, and in what manner? Now, Bogdan, you get a Jan Werner question from me, which is, I like the fine distinction between general and individual militant democracy measures. But of course, parties are banned if you can show that the party leaders acted in an unconstitutional manner. So is this distinction between individual and general measures is really that important in practice, and is it helpful in the election context? And this takes me back to Vlad, which is a question. I really appreciated your analysis and the weaknesses of the judgment. So what's the proper role of the Constitutional Court going forward? What is the proper role when a timetable is set finally, and what will be the proper role in whatever dispute arises from the next round of elections? I stop here and I look forward to hearing from you.
Thank you very much, Renata. Balázs, please.
I will be very short to let time for the discussion, so I will have just a couple of short questions, and obviously from the perspective of the project STEPE, which is about transfers of these illiberal and other kind of ideological practices. I'm interested in mainly on the universalization or transferability of this contextual ruling, and like how far we can expect, and if we expect similar things, then where it can go. And one question is that, and I'm thinking a little bit about counterfactual, so like what would be the whole thing if there would be something a little bit different that is, for example, in a different context. So my question is that would there be a similar, or could there be, or should there be a similar ruling if, for example, the same person with the same background comes second? Yes, so like that he gets into the, so like the Vadim Tudor situation, yes, that like he's not the dominant, but he is still getting in with the same Secret Service background, the same TikTok, whatever. Would there be a pressure on the Constitutional Court also to do the same that they were doing? Second question is, what about a non-presidential political system? Like the Romanian system is quite presidentially loaded. I mean, what about political systems where you basically have much less power of the president? Would there be again a pressure on the Constitutional Court to intervene with the same severity if the balance of power is differently defined? And the third question is that are we not falling into the mistake of the populist understanding of democracy to be surprised about the restraints on majoritarianism, given the fact that the whole political culture of the post-Second World War, I mean, like this is the whole militant democracy tradition for a very long time, was very much about limited democracy. Yes, I mean, there was a very serious kind of intervention, not necessarily of constitutional courts, but different other agencies to kind of vet basically who is eligible and who is not. And I mean, in some ways, isn't it a kind of recent phenomenon that we are kind of presuming that there are no preconditions in a way, that we are just kind of letting majoritarian dynamic to run? And the last question, I think, to a certain extent, Perju was touching upon this as well, that it's a very interesting situation that, like, in contrast to Trump or other paradigmatic populist political leaders who were actually instigating, and also Orban in 2002, instigating mass protests and were actually trying to take back power or from the street or on the street. I mean, here it's a very interesting situation that we have a paradigmatically populist political force. We have a relatively strong majority, as you show, in favor of not intervening by the Constitutional Court, but at the same time, there is no visible political popular protest. So basically the society is very, very silent. And I would like to kind of ask you about this seeming kind of contradiction of how can we have a populist who is kind of theoretically riding on mass disappointment or disaffection, and on the other hand, this disaffection is not manifested in any kind of active political activism, so to say. So thanks a lot. And this was very, very interesting, or whatever we heard so far. So I'm very much hoping that also the audience will have intervention.
Okay, thank you as well, Balázs. So we have now officially opened up the discussion to the audience as well. So whenever you feel comfortable, you should write your questions on the chat of this meeting. Can I ask you to answer to these wonderful questions? I don't, take your time or adopt your own priority in this, please. I don't know, maybe Bogdan this time?
Sure, why not? Thank you. Thank all the discussants for really challenging questions. Now, let me address Dietmar's question about did they announce? I do not know. I do not follow political news. I have no idea if they announced or not. And quite frankly, it doesn't interest me at all. But your question regarding the Venice Commission, whether it was a vindication or an accusation, an indictment, of course, Venice Commission reports, and this is a relatively high-profile report, I should note. There's Grabenwarter there, president of the Austrian Constitutional Court, the Cartabia, former president of the Italian Constitutional Court. So it's quite a heavy load. The former judge, the EC, in respect of Germany, the ECHR, Angelika Nussberger. Now, regarding the disqualification, I would like to draw our attention to paragraph 63 in the urgent report, which says another question is whether a candidate who has manipulated elections is excluded from new elections. According to the findings of the Venice Commission in 2009, this was not the case in most member states. That said, criminal conviction of candidates may lead to ineligibility. This and many other positions of the Venice Commission lead me to conclude that this is not a rubber stamp at all, or not a favorable view at all in any way imaginary. Of course, one tried to spin it in various ways in the news because this is not a very good news in the current context. But what the Venice Commission basically says is that courts are reactive, so they don't take initiative. You have to have a procedure. Someone has to seize them with a complaint. They cannot just meet informally and invalidate elections, no matter how much we would like that. That against a first instance decision, either of the court or of the election bureau, there should be an appeal. You don't decide in first instance, and that stays definitive, as it was the case with King Solomon, for instance. No, that's not rule of law. Now, there is the question about classified intelligence reports, and I urge you to read the reports. These are 3-page documents. Some of them are annexes to annexes of unclassified reports, which means that they will not be classified really, but they were compiled ex post, right? So, which is a problem, one should think. The longest of them is the telecommunication service report, it was 21 pages long, which says that there was no problem. So what's to be done? No? And the entire decision is 10 pages long, double spaced. You would fail students for seminar papers shorter than that, perhaps. No, so it's quite a problem with the Venice Commission report. I do not think it vindicates the Romanian Constitutional Court at all in any way imaginary. And the problem, and this goes also to Renata's question, one of them, the problem with individual and collective militant democracy. The problem is that when you use such measures against an individual, unless you have a procedure like you have in the Grundgesetz, Rechtsverweigerung, right? Unless you have that. If you have that, that's not a problem. But if you do not have a procedure like Article 18 in the German Constitution allows you to use, and you want to invalidate elections or disqualified candidates, the procedural requirements in European law, in Venice Commission standards, including in this reports, are much, much higher than those that are applicable in the case of parties. And an irony of the situation in the case of the disqualification of Mrs. Șoșoacă was that they used the argument from letter K, declaring the unconstitutionality of a party in the invalidation of a candidacy. Whereas if you use the procedure for a party under Romanian law, the procedural requirements, the procedural bar is significantly heightened. You need to cite the representative of the party, you need to cite the complainant, they have to have the right to defense, you have to have hearings. So, see? So I don't think this is a vindication, and unfortunately, I wish that were the case. Regarding Renata's question, which is pertinent here also, now, the problem with the Romanian Constitutional Court is not that it's elitist. I don't think that many consider it so. It's not really the elitism of the Constitutional Court, and I do not want to appear as an attacker of the court. The court has done many good things over the years. It has stabilized many situations. It has its value in the logic of Romanian democracy, perhaps not on this occasion. And it all started with the Shoshuaka decision, which arguably has altered the results and has led to the actual situation, the situation that we find ourselves in, right? So in a way, maybe that's the best vindication of Benjamin Franklin's saying that honesty is the best policy. See, if they had followed the rule of law in the Shoshuaka case, we would probably not be now in the situation that we are. It's really an irony of history. Regarding whether or not there is a difference between individual measures, I think, Renata, with all due respect, I mean, I take your point, but I think that there is, because in the case of party bans, you need standards, as you know, you know that. In the case of a party ban, it's not only about the leaders, it's about the structure of the party, the platform of the party, the program, whether you can challenge leadership, whether the democratic, or at least that was the standard that the Germans has instituted in 1952, 1956, and then they changed. Now the standard is the darauf aufs Gehen, whether the party has a likelihood to overturn the free democratic order, which of course is another problem, because how are judges capable of deciding probabilities? No? Which also leads to whether they are the best judges of partly declassified, partly compiled after the fact security reports. No? Thank you. That's. I think I have impliedly addressed Bolaj's arguments in the answers to the other two commentators.
Isabella, do you want to intervene?
So we have two questions from the audience. I'm just going to read them out. Alexandra Demyanenko is asking, and I guess, Sergio, this might be a question for you. Is Romania's policy of support for Ukraine expected to change in the context of Russia's war against Ukraine and Ukraine's accession to the EU, considering the internal political situation in Romania itself? And the second question is asked, Alexandra Ogussi asked the second question. This is a question for the three of you. It seems like you are talking about a normal European constitutional democracy, whereas Romania has been undergoing a process of de-democratization, autocratization for many years. From this perspective, how do you view the repeated changes to the electoral calendar in 2024? Aren't these a cause of the institutional crisis the country has entered? Do these 2024 changes to the electoral calendar meet the standards of a functional democracy? Finally, do you believe that given the current political regime in Romania as of February 2025, the country would still be accepted into the EU? Maybe we give Vlad or Sergio a chance to answer first.
Yes, so let me say a few words to some of the questions that have been asked. I think that on the question whether Shoshuaka and Georgescu will run again, no idea on the Shoshuaka part of it. With Georgescu, something very interesting has been going on, which is that over the past couple of months, after the annulment of the elections, and as we've been waiting to see when the new elections will be scheduled, he has become much more present in the media, much more active, rallying his troops, galvanizing support, and making various political statements that essentially place him completely within the Shoshuaka precedent of the Constitutional Court, doing thus something that's really quite baffling. If he had his lawyers would tell him, don't say these things, but he's saying exactly those things, which suggests to me that he is fully aware of the fact that he will announce his candidacy. His candidacy will be challenged, and it will be deemed to be unconstitutional. It will be invalidated. He will not be able to run. And then, he's got his own political game going on. Which I actually think is really interesting, right? Because it's sort of like he's no longer playing by the rules, because the rules are, of course, not advantaging him at all. But this goes to a little bit to Renata's question, which sort of what's the proper role of the court moving forward? It seems to me, again, sort of as a technical matter, given where things happen to be at this particular moment, it seems to me that the court and seeing Balazs's point about, what do you do when somebody comes in second? It seems to me that this idea that the court is it seems that things are going in the direction of an automatic constitutional court confirmation of the constitutionality of a candidacy to the presidential office, because you cannot have you cannot have this problem again. That is, you cannot again have a candidate that might win, whose candidacy is unconstitutional by the standard you've announced, but you haven't had the chance to review that. So you can no longer wait for a complaint to the constitutionality, even though these are going to come undoubtedly from now on in all directions to everybody. But still, you can't wait. So then it's going to be some kind of ex officio constitutional review of the candidacy, which of course gives enormous power to the Constitutional Court, absolutely enormous power. And it gives enormous power to this Constitutional Court, and that's a problem. And it gives enormous power to future Constitutional Court, and that's going to be even more of a problem, since it's fine to assume that future Constitutional Courts are going to be, possibly captured by the, far right that will eventually come into power, given where things seem to be going with the Romanian political scene. So that's a big problem. But that's where things seem to be going. Look, there's something to be said, and the big part to be said. If you look at Romania over the past decades, couple of decades, with a very vibrant civil society. The Romanian civil society has not been silent. A big reason why Romania is not Hungary, why Romania is not even Poland, is that sort of the Romanian civil society has been very vibrant and really stepping up and speaking up. I guess this goes to sort of Sergiu's point about, actually pay attention to the people and pay attention to how sophisticated and nuanced their understanding of the political situation is and her analysis is. I will say that, Dietmar asked a question about, what can the Romanian Constitutional Court contribute to what's coming to, other political, other jurisdictions. I don't want to answer the question necessarily about the Constitutional Court, but I do want to say that, yes, I agree that sort of the judgments, the documents, the sort of security intelligence services documents that the Romanian Constitutional Court has referred to, appear to be really quite thin. There have been really some, if you compare that, for example, with the analysis that the intelligence services have done in Moldova, of the way in which sort of the Russian influence has attempted to go online and influence the services, those are really interesting and very thorough. So the Moldovan security services would have something to tell sort of the German service and the French services that are undoubtedly now getting ready for exactly the same. Also, the French report of the French government from a couple of days ago is very useful. To Bogdan, on this question, I think maybe this is not the moment for the conversation, but first of all, I mean, just how striking that we're talking about the details of Romanian constitutional doctrine, and this way of sort of in this conversation. But if that's what we're talking about, it seems to me that there's sort of like two critical points that you make, and I would like to hear more about them. The first one is, your very interesting point that, institutions should not be deriving concrete powers from sort of general constitutional provisions, and how interesting it is, because, explains so much of the debates that we have seen in the United States, where the president of the United States is trying to derive so much powers from a very general provision, Article 2 of the US Constitution, the vesting clause. And out of that vesting clause, a general provision, have come all sorts of very specific provisions. I don't mean that to say that, look, it's fine because they have done it. It might be not fine precisely because, you know, the US has done it and has shown the enormous dangers of doing exactly what you recommend that it not be done. The problem, though, is that the Romanian Constitutional Court has already done that countless times. It has countless times read specific powers in the very general provision that it is the guarantor of the Constitution. So that's one problem. The other one is that I think that even if you were right that the Șoșoacă case is really a departure from precedent, a major departure from precedent, the Șoșoacă case is there. So when Georgescu is going to be invalidated, it's going to be invalidated by reference to the Șoșoacă case. And that's that. And then there's the question if the Șoșoacă case is that much of a departure from the case law. And there I think, maybe we can have our conversation sort of ourselves offline. I do not read the decisions of the Romanian Constitutional Court as going to speaking to the democratic aptness, as you called it, of a candidate. I mean, the Funar decisions, the decision regarding the guy who was the leader of the car, whatever, automobile party. Those are decisions that don't really come close to this, even if you were to look not just at the language. I agree that sometimes the language of the court, you can interpret it as, speaking to the fact that the conditions are exclusive and limitatively mentioned in the laws and in the Constitution. But really, if you look at the kind of challenges that have been presented, if you look at the challenge, the constitutional challenge to the validity of the Șoșoacă candidacy, and you compare it to the other ones, including to the one that Vadim Tudor has presented to Funar's candidacy, they don't really come close. So I just don't think that the court had spoken to that. Now, that's not to say that this is what they did with Șoșoacă was the right thing to do. I mean, it has placed us exactly in the situation where, in my response to Renata, the next steps are, however you think about it, are very problematic. Anyway, I'll stop here.
Perju, if you want to briefly respond as well, thank you.
Yes, of course. I will try to address the questions that were not less addressed by Bogdan and Vlad. So the question of Renata was if the decision was a bad thing finally, if this judicial activism, let's call it like this, of the Constitutional Court is a bad thing per se. It's a bad thing in that it could create a precedent that could in the end be used in a totally upside down way by a next majority in the Constitutional Court. And we have also to look more precisely to the profiles of these judges in the Constitutional Court, and also to see that when cases such as the one of Funar or Vadim Tudor were there, we had other people in the Constitutional Court with a different kind of views and mental minds in sets in culture and so on. And we can anticipate that this could be in the future also subject to a change. Who should have acted if not the Constitutional Court? Well, the answer is quite simple. We have nevertheless a police and the prosecutor's office, and they should be aware of the attempts to destabilize countries via different tools that are not democratic. They should also be aware of the attempts to fraud the elections and so on. The Constitutional Court is a very small gang of people who are already accused of everything bad happening in the country, so they should not wear this responsibility. And we need to stress that this was a very important decision, not only in the economy of the presidential elections, but also in the economy of the parliamentary majority, which is much more important than the presidential elections. Once elected against Lasconi, which was very possible to happen, Georgescu would have been the one to appoint the new prime minister, to shape the new majority. And we already had, at least in one of the two major parties, in the Social Democratic Party, a branch that was much more inclined to merge, to join forces with the nationalist extremist parties in order to create a majority. So what was in stake was not only the presidency itself, as it would be the case now in May, but also the orientation of the country geopolitically and the policy of the country via the majority in the government. And that's why I think this decision was much more political and much more, let's say, salvatory in without being dramatical in on a long term. Now on the question of Balázs on mobilization and the lack of mobilization against the decision of the Constitutional Court and the new political set, I think that there are two explanations for this lack of mobilization. The first is rather sociological, the second is rather partisan and political. From the sociological point of view, this was the first time that these different profiles of those who Georgescu succeeded to attract in his discourse merged and had political outcome. I won't have the time to insist here, but given the diversity of the profiles of the voters, they were very difficult to co-opt in a cohesive movement on the street. They are very easy to be mobilized online, but very difficultly mobilized in the streets. The fact that there is among many voters paranoia and the conspiracy theory related to the fact that they are tracked, they are themselves under surveillance, and the only thing that they can do is to protest against the system via voting an anti-system candidate. This shows why they did not have even the guts to go there on the street. And then politically, the mobilization would have been possible if those were voters of the same party. And let's not forget that there was a competition between Simeon, who had the most organized and still has the most organized party behind AUR, and Georgescu, who had some sort of a very nebulous matrix of voters spread all over not only the country, but also in the diaspora and elsewhere. And the result was that the two strategies did not match. They were rather competitors until recently, until AUR decided to now to back Georgescu for presidency. But when doing this, we have to bear in mind the calculation that they make. Simeon bets on the fact that Georgescu's candidature will be rejected, and he would be the only one able to represent the nationalist pole and gather the votes there. So that's the explanation for the lack of cohesive mobilization against the decision. But now we see that, for instance, on the 24th of January, with the demonstration on the Principalities Union days, we do have an increasing number of people going up on out in the streets, backing AUR and backing Georgescu. So I think that this taboo has now fallen. They are about to be more active even in the streets. And maybe to answer the questions online also, the question of Alexandru is very, very interesting, of course. On the electoral calendar, yes, it had a very important influence. We did not have the time to discuss about it, but it had a very important influence in creating precisely the narrative that the system works against the people. The fact that the local elections and the European elections were merged by the beginning of June, and the Social Democrats and the Liberals won by far, especially within the European elections, pushed lots of anti-system voters to gather around the idea that they need to do something in order to change, because it's inevitable that they would do the same in November. And then when they decided to create this system with the parliamentary elections caught in a sandwich between the two rounds of the presidential elections, this was the sign that there were first some problems within the coalition who had different candidates, and this division needed to be speculated. And also that because of this monstrous calculation, the electoral calendar that should have been established maybe 1 year or even 2 years ago is now tailored for the parties in power. This gave ultimately the courage of many to contest frontally the system itself, and they let's say they had a strong reason to do so. And then we have Alexandra's question on Ukraine. If there was a cut between the two camps for remaining camps for the second round in the would-be second round of the presidential elections between Lasconi and Georgescu, Ukraine was one of the major topics, and many people showed through their ground researches, not yet published, but under publication because it was very recent, that if there was a divide, the divide was also based on the opinion about what Romania should do in relation with Ukraine, with lots of voters of Georgescu being opposed to the help towards Ukraine, being inclined towards a peace with Russia, and then with a much more intransigent position of the voters of the others, and especially of Elena Lasconi. Now, of course, what happened during the last month, especially after the election of Trump, has some consequences over the elites who show, let's say, maybe a higher degree of reluctance to back totally the decisions in favor of Ukraine, trying to win especially some time to see how things will evolve and how to position Romania. But there is, in comparison with what was in November, in early February, let's put it this way, there is some sort of a switch in the way the elites regard the possibilities in relation with a future would be peace, which could be defavorable to Ukraine, repositioning in this way a little bit Romania on this map, not to fall on the wrong side of history, as we often say here. Thank you.
Well, thanks, Sergio. Bogdan, I think you'd like to answer to Alexander Rugusi's question, and we have a third question that somehow matches with this one. So I'd read this out first, and then we have a final round of answers. So what should be the next steps in the Romanian case? It seems most of you would agree the decision was problematic at best, if not completely undemocratic. Where do we go from here? How do we make sure CCR will not play with what to me seems a political role? The decisions in the previous months have opened the way for abuses of power while generating additional crises in the political system. And finally, in my opinion, the CCR decisions have been useless. Any political party will learn from them, and it is quite possible to have a populist candidate that would run a smart campaign without any mention of unconstitutional topics, then once in power, ... So, Bogdan, maybe you might go first.
Thank you, Isabella. No, To my colleague Alexandru, I should like to make it clear that I never called Romania a functional liberal democracy. I hope that much was clear from my presentation, and if it wasn't, I would like to restate that. However, there was one thing, whatever steps were made towards a functional liberal democracy in Romania were made after 1989. So the first time we had peaceful transitions of power through democratic elections were after 1989. No? Before 1989, the only time that happened was in 1919, and it took only 4 months before the parliament was dissolved. So I wouldn't put down the Romanian post-communist democratic efforts towards whether Romania would be able to join the European Union nowadays. I don't know. Let's ask Mr. Kickel, for instance. No? So there are many countries that wouldn't really be able to join the European Union nowadays, and the European Union nowadays is not what it was when Romania joined it either. No? So there are problems everywhere. I wouldn't bring back the ghosts of the early 1990s in 2025. Let's deal the hand of cards that we have got. And a quick aside to Vlad, but of course we will continue our bantering over email, so there's no need to prolong that here more than it is necessary. Shoshaka is already there. Yes, but you see, that's like saying the child has broken the vase. Why not break the TV set? See, the fact that a faux pas, a bad step, an instrumental decision does not justify a long series of instrumental decisions afterwards. But I do agree that the situation as such is terrible. Whether we take the child to Bucharest on a trip, like in Caragiale, we will see. Okay, that's all I had to say.
Well, thanks, Bogdan. Vlad and Sergio, would you like to answer to the chat questions? Also, Sergio, you already answered partly, but Vlad, would you like to add something?
No, I mean, look, I think the decision of the Constitutional Court is problematic. Is it problematic because it's undemocratic? I don't think so. I don't think that that's the way to think about it. You know, is it useless because any politician is gonna know their way around it? Again, I don't think so. First of all, because there are, you know, the existing politicians, you know, already have a track record that they can't really erase. So if you imagine the Constitutional Court now applying this, you know, pro-Christian bed to the various candidacies, you know, it might be problematic. So, you know, they can't erase what they've already said. But then, I mean, you know, on the basis of what it looks like right now, it's a very funny thing because the court in the decision that annuls the elections, it speaks to the importance of respecting individual rights, including the right to be elected. So that's a ground on which it claims to be annulling the elections. At the same time, if you look at the Shoshaka opinion, and not just Shoshaka herself, but sort of, you know, the afterlife of this opinion. And if you pay attention to what Bogdan was saying about the distinction between rulings and decisions, then you'll see that, you know, it becomes really quite easy for the Constitutional Court to invalidate, to deprive right holders of the right to be elected president of Romania on grounds that are really quite flimsy. on grounds that, are what? Some kind of, themselves protected by free speech. So it becomes tricky in that kind of like logic of rights. And in a sense, that's no surprise, right? Because one thing about our rights is that once you start paying attention to them, there are rights everywhere and they conflict, and it's all very messy. So I don't think it's useless. I mean, I think this is gonna, if taken to its logical conclusions, and it might be that it will not be taken to the logical conclusions, but if taken to the logical conclusions, the Șoșoacă opinion, which, as Bogdan says, has started the whole saga, is going to fundamentally restructure the nature of Romanian politics. Now, granted, the court mentions the fact that the way in which presidential elections are run and its own powers in overseeing presidential elections is very different from other elections. It's very different from parliamentary elections. There's something special about the presidency. So it's going to be the presidency that they're going to be going after, but also pay attention to Sergiu's point about the high stakes of the annulment of the first round of the December 24 elections, which was not just who's going to be president, because if you think that that's all there was to it, then you would say, well, but look, there are mechanisms of dealing with a president that has gone rogue. You suspend the president, right? It's been tried before, it's happened before. There are ways in which parliament can act against a president that has lost it. But once you realize, as Sergiu says, that the issue here was something much more significant, also geopolitically significant, which was a way of carving out the parliamentary majority by co-opting the wing of the center left that has already, that seemed very open to collaborating with far right, if that's what these guys are. And have, Mr. Ponta be, appointed prime minister, which I'm sure he would have very much liked, if only he could bring enough votes to establish a majority. All the disputes on the far right between Simeon and the other leaders, I think that once they had found themselves within reach of real power, they would have managed to become friends. So that was the issue. And that was the issue at the time when, there's the war in Ukraine and everything else. So this, again, I want to end on a note that is even, I don't know if it's even more pessimistic, but I just think that it should be mentioned, the fact that there are deep concerns that are, I think, legitimate concerns. I don't have inside information, but concerns about the role of the secret services, of the intelligence services in this entire story. The timing of the annulment of the elections might very well have been, when the intelligence services would have informed the court that Mr. Georgescu is quite likely to win the second round of the elections. And then the court acts. There's a former judge on the Constitutional Court, Daniel Morar, a loose cannon, but who on camera, in a documentary, investigative journalist documentary, has essentially talked about the influence that the intelligence services have within the court. So these things are there. You would imagine that since it appears that a lot of what's going back to Sergiu's point, a lot of what's going on here with the rise of Georgescu, with the candidacy of Georgescu, with it seems to be a conflict within the Romanian intelligence services. You would imagine that these guys are all over what's going on. So then here we are discussing the details of constitutional doctrine. But I still think that that's what we can do, right? I mean, I don't know if this is separation of power, division of labor. It's not separation of power. They've got no power. If it's division of labor, because this is the kind of stuff we can do. What else can we do?
Yes, and maybe I think this is a wonderful last word, because it's really the question, what can we do? I mean, we can discuss, bring in a really, really rich and differentiated, create a really rich and differentiated picture, which at least for me, as somebody historian of Western Europe, really brought a lot. I learned really a lot. So thank you very much. And I think we should continue this kind of discussion, because it's a kind of labor division, yes, on the one hand, but it's a very important labor division. Just really to say, well, there might be this aspect of intelligence service that is maybe doing things that well aren't at best, but at the same time, it's by talking about this, bringing this in, discussing this, and having like this pro and cons. I think this is the best we can do, really, to give some kind of orientation in a politically precarious situation. So thank you very much for these great inputs, for the discussion, which I really liked a lot. I learned a lot, and well, thank you for the audience, for your patience. Thank you for the questions. And yes, I think we're going to continue this kind of conversation. And so please stay in touch. And well, as Bogdan said, you can also continue via email if you have questions, or if there's a thread that hasn't been discussed enough today. And I'd like to invite the panel to stay for some more 5 minutes or so in the Zoom meeting. And well, goodbye to the rest of you. Well, I think it's only us left.
Even Georgescu left in the end.
Exactly.
But I realized I could put some people in the waiting room. I did so.
Yeah, I moved some people in the waiting room, and now I'm
too. Well, perfect.
This is very violent.
Well,
I think it worked very well, this format. So it was vivid and interactive, more or less. And
yes, I mean, we had over 60 participants. So if we
A lot.
the 9 of us, it's still more than 50 participants, and they remain quiet for quite a long while. So only
the
after
only surprise I had is that the majority was Romanian, and I was expecting that exactly people who are outside of Romania are hunting for information, and it looks like that Romanians are also at a loss, or they wanted to get confirmation of their kind of.
Actually, I got a lot of feedback when we were publicizing this. Why don't we do it in Romanian? Because actually there is a huge need for a wider public debate about this. The fact that the Constitutional Court didn't really, and it probably could have done a better deal in justifying this. But it's not just the Constitutional Court; it's the wider political system that failed to actually create the space for a public deliberation about it and broader public discussion about it. And I think, especially as Sergio mentioned, this coincidence of parliamentary and presidential elections meant that everyone actually has a stake in it. no one except the president actually who have, now, even if a lame duck, but he should have played his role in a way, but he didn't. He never did in a way. He should have kept this kind of anchor of public reason in the whole debate. He never did anything about that, and everyone else was part of it, right? Very much a partisan actor of this. No one caring about the public deliberations that's so needed about this kind of thing.
Mm.
Le gouvernement de service de renseignement.
Yeah, so I was having this, I mean, the Romanian case is so complex that I didn't dare to ask this question I had in mind, but this would be like the outsider question is, of course, well, is there something, is there a very, it's a very European element to it? So if can we adopt this or transfer this case to other European political crisis situation where populist movements become so strong that constitutional courts might intervene? So is there something, a European lesson we can learn of this? So this would have been a question, I think, well, but it was the case as such was already complex enough, so I just didn't want to add this layer.
There are discussions in your own country about, as you know, about a party ban on the AfD. Luckily, Scholz and the others in the elite are smart enough to know that you cannot ban a party that has 20% of the vote.
Yeah, and the constitutional hurdles are high, so they really are, because you have to showcase that it's not only on the ideological level problematic, but there's some kind of real action that is against the constitution.
Well, the question is that if Elon Musk will start to do the same as he was doing in the United States, that is basically making lottery for all the voters for AfD or something like that, then what the German Constitutional Court does, yes? So like because like just imagine like a couple of $1 billion on the bank account of AfD and then how the campaign will look like. And then what will the other parties do? You know? So I think like we can get very quickly into similar.
At the moment, we have a billionaire from Austria who's sponsoring the AfD.
Yes.
I mean,
Okay.
look, it's at the moment you can just hope that Musk is more interested in the UK, where his money will buy him more than in Germany. Germany is too large for that, but it's ridiculous that in the UK the discussion is about whether you can ban companies from making contributions to political parties, because everyone is using non-incorporated associations. But the European dimension, I mean, the French report, which Vlad mentioned, is essentially in close cooperation with the European Commission. So it's a wonderful question how far the Commission is willing to go when it comes to Russian disinformation in member states' national election campaigns, and actually what the basis is for that, which is whether they are also going to do that in accession countries. And think a little bit about what that means for votes on accession. But as far as I understand, Isabella, one of the biggest problems in Germany is that you have a fairly high proportion of AfD and even further right sympathizers on the ranks of intelligence services. So this whole, what do you do with a divided intelligence community, which Vlad very kindly took up in his response, is I think really crucial, because you can only challenge them if you have a security clearance, and you only have a security clearance if you are considered safe not to challenge them, right? So that's a bit of a conundrum there. Anyway,
There was also an interesting, if I may just briefly, an interesting information that in the handbook, the Kremlin's handbook that was vehiculated, there was the idea of self-fulfilling prophecy. The fact that more that they speak about us, the more they exaggerate the importance, the capacity of this malicious Russia to intervene through different octopuses working behind the secret services companies, trolls, bots, and so on. More these societies would be in panic, and the reaction would be rather to cool down in order to accept what is inevitable, creating this story of success of these parties, groups, entities, leaders sponsored by Moscow. And this is something that could be addressed by constitutional courts or constitutional councils. In the end, I think only, how should I put it, doing it the Romanian way. So believing that this is too important to be left aside, and deciding to act for saving the country as an ultimate recourse, not as a usual practice somewhere. And that's something that may appear in the future.
Thank you so much, Renata. Thank you so much, everyone. I will not name you because you have already been. So yeah, we already have a basically working group on the constitutional elements of elections and survival of European elections and beyond. Thank you again. I am left with Balázs, do you want to say something in closure?
Numai să spunem că mulțumim frumos, adică se pare că toți care au rămas vorbesc românește.
Așa este, da. O seară bună!